clerk, I believe you had at least one note to provide to me.
Yes, Judge.
Okay. Of course, we discussed our plans for proceeding yesterday, and we know that another, what we're referring to as the third panel, will be returning at 1 o'clock today. I've been advised that among that number is prospective juror number 163, who has become ill and is not doing well today. I think we need to go ahead and address that matter now, rather than if that indeed is the case, rather than have somebody come down here in that circumstance. I can hear from counsel on that.
No objection to her, excuse me.
Judge, I have no objection to him. The court's discretion, if you wish to excuse him for cause, that's fine with me.
All right. Thank you. With that, we'll advise the clerk to advise jury services. We'll let number 163 know. I hope he gets better. He does not have to report this afternoon.
Yes, Judge.
We'll note that on the record. Now, I've also been advised by one of our bailiffs just a moment ago that among the number that we'll be addressing today, and in fact, let's make that correction on this form, and you can make it on yours, but I've been advised that number 138 has just a moment ago approached one of our bailiffs and indicated that after giving it some thought, he thinks he may have some knowledge of the case. So I go ahead and provide that information to you so that you can add him to the list of those that would be subject to the individual voir dire.
Nothing less, Judge.
No, sir. All right. Then we're ready to proceed. Number 108 indicates knowledge of the case. Have a seat. We're going to allow the attorneys to ask you some questions. I ask you to speak up in a strong voice as you respond. Stay.
Thank you. Good morning, ma'am. You've indicated yesterday that you had some knowledge about this case from some source outside of court before you came in. Is that correct?
Yes.
What was the source?
I remember seeing news stories after it happened.
Back in around 2011?
Yep.
Do you recall seeing anything recently?
A few stories that have popped up, here and there on the internet.
Okay.
That's about it.
I see that you work as a paralegal.
Yes, I do.
And so you've had some training in broad areas of the law, is that correct?
Yes.
Okay. So I'm going to talk to you about some principles you may already be familiar with. Everybody charged with a crime in Florida, and part of our country, is presumed innocent. That's got to be a juror's starting point. You're familiar with that, ma'am?
Yes.
Okay. And it's the state's burden of proving the defendant's guilt beyond and to the exclusion of every reasonable doubt. The presumption of innocence stays with the defendant until such time that the state accomplishes that. Do you understand that, ma'am?
Yes, I do.
Okay. It's important that the jury return a verdict based solely on the evidence in court. Fair enough, ma'am?
Yes.
Okay, so I want to ask, well, yesterday the judge read a summary about what the case was about. Okay. Can you tell me what information, in addition to what Judge Battles informed you, what information do you recall about the news reports concerning the case or Mr. Schenecker that was not contained in the summary that Judge Battles gave you? Do you know what I mean?
I think that the news is very kind of vague as far as details are concerned. The only thing that I really know is, you know, she came to the house and pulled the gun on her daughter and her son. That's really all that I know.
Okay.
I don't know specific details.
Did you see any photographic images or video images of the defendant in any of those reports?
Probably only the picture of her after she was arrested.
Was that still or was that video?
I think it was still.
Okay. Did you draw any conclusions or impressions about the defendant's innocence or guilt or her state of mind as a result of your viewing that image?
To be quite honest, I just don't. I don't watch the news very often because I just think there's too much bad stuff on there. So it's really just kind of a blur when it goes by. I don't think twice about it.
Have you formed any fixed or definite opinion as to the defendant's guilt or innocence as a result of your exposure to the media or in general?
No, not really.
Okay. Would you be able to afford or give to Ms. Schenecker her constitutional right to be presumed innocent?
Yes.
And would you be able to hold the state of Florida to its burden of proving guilt beyond and to the exclusion of every reasonable doubt?
Yes.
Is there anything about your knowledge of the case as a result of the media exposure or any other source of information that you think would prevent you from being a fair and impartial juror?
No, I don't think so.
Okay. Thank you, ma'am.
Mr. President.
Good morning.
Good morning.
Can you recall back in 2011 or even recently, what is your primary source of receiving the news?
My primary source, I would say, would be the internet. Because I usually don't watch the news at home. I have a little boy, so I don't let him watch a lot of things on television.
So you get on the internet and that's your source of news primarily?
Mm-hmm.
Do you have a particular website, tbo.com or anything else? Do you have a particular website you look at?
Usually it's my homepage, which is MSN.
Oh, okay.
So I don't usually surf around a whole lot. You know, that's the thing that comes up on my homepage, and that's what I usually look at.
Your memory of what you have seen about this incident and about our client, Ms. Schenecker, that would largely have come to you from MSN?
I think so, yeah.
Okay. Do you recall if there's any other details that you may have in your mind about this other than the ones you've already mentioned?
I mean, I think reading a couple of stories, it may have said that, you know, she was a soccer mom. She, you know, did all these things with her kids, and but that's really about it. I mean, like I said, I kind of read the story and then I don't think about it.
And in terms of, and you're the only person that can answer this, so you haven't had any kind of preconceived ideas before you came in here, any firmly established opinion about guilt or innocence or the way this should go or anything like that before coming to the courthouse?
No, I don't think so.
Okay. In terms of innocence or guilt, obviously Mr. Quinter just talked to you about that a second ago, the presumption of innocence. Is that a term you're familiar with from your work? Mm-hmm. And do you feel comfortable with extending a presumption of innocence right now and throughout the proceedings to Ms. Schenecker?
Yes, I think so.
Until it overcomes that? You listened yesterday when the judge explained the role of the juror, and we're in need of people that can listen to the evidence as it comes to them from the witnesses here in the courtroom, dismissing, setting aside the things that you may have brought to the courthouse with you. Are you able to do that?
Yes, I think so.
I have no other questions. Thank you.
Okay.
Thank you, ma'am. Ms. Scott. Panel members exit the courtroom. No motion.
No motion, Judge.
Okay, thank you. Number 109 indicates some knowledge of the case. Yes, ma'am, you can have a seat. I'm going to allow the attorneys to ask some questions. I ask that you respond in a strong voice so we can hear you.
Good morning, ma'am. You've indicated yesterday that you had some knowledge from this case as a result of some outside source. Is that right?
Right, correct.
What was the source?
The news, newspaper, radio.
Okay, multiple sources in the media?
Correct.
Was your exposure recently, or was it sometime closer to the incident in 2011?
Both times.
All right. The defendant has a constitutional right to be presumed innocent. That's the starting point for the jury. And that she must be presumed innocent unless and until the state of Florida proves her guilt by evidence in court, beyond and to the exclusion of every reasonable doubt. Do you understand that principle, ma'am?
Yes, I do.
And what's important for both sides in this case is that the jury as a whole and individual jurors base their verdict only on the evidence they hear in court and is presented in court. Fair enough?
Right.
Okay. With that in mind, can you tell us, well, did you hear yesterday Judge Battles read a summary of what this case was about?
Yes, I did.
Okay. What I'd like you to do is to think about all the information that you heard in the reporting or read in the reporting, and tell us if there was anything that you recall about that information that was in addition to or different from what Judge Battles read to you yesterday.
I would say that maybe the fact that they came and found her outside on the lanai with the children dead in the house. I've heard things also in addition to that on the news, you know.
And what was that, ma'am?
I've heard that she had trouble with her children, that she had been arguing with her children for days beforehand, that she didn't want to wait 3 days, and also there were, you know, psychological problems.
Okay.
So.
Did you see any images of the defendant, whether it be still photography or video images?
Yes.
And what was it that you saw?
Just the shots that they had shown on the news.
And what were those shots of?
I believe like mug shots. I can't remember exactly.
Do you recall any moving images? Any moving, and by moving I mean not emotionally moving, but
No, I didn't.
physically moving?
No.
Okay. As a result of what you saw or heard, have you drawn any impressions or opinions as to the defendant's guilt or innocence of this crime?
Yes.
And what is your opinion or impression that you draw?
I believe that she committed the murders.
Okay. Is that something, how would you express the strength with which you hold that opinion? Mildly, strongly, fluctuates? How would you describe that?
I would say pretty strongly. I just don't see how someone could, you know, kill their children or have a children murdered in their house and then just go outside of the pool.
Okay. With that opinion, do you think you're capable of giving the defendant what she is constitutionally entitled to, which is her right to be presumed innocent?
Unfortunately, no, I don't think so.
And is that, and there's no doubt in your mind that of your inability, is that correct? Okay. Thank you, ma'am.
Any questions, Counsel?
No, Judge, I have no questions.
Thank you, ma'am. You may step out. She's asked the court.
Judge, I move to strike for 109 for cause.
May agree. Without objection, 109 is struck for cause. 110 indicates hardship.
Yesterday you indicated that service on this jury for the better part of the next 3 weeks would cause you hardship. Would you explain, please?
Yes, sir. I'm a commissioned sales representative, so 75% of my sales are based on me actually making the sale. So, being out for that period of time would certainly diminish my earning capacity.
Okay. Excuse me for asking these prying questions, but we need to follow up so that an informed decision can be made, okay?
Yes, sir.
Do you have any dependents that rely upon you financially?
Yes, my wife.
Okay.
She's unemployed.
All right, sir. Do you have any other source of income, whether it be savings or investments or family, that would help you if you were to serve?
It would be strained, but I probably could pull it off.
Okay.
Yes, sir.
And of course, everybody understands the impact of not earning for weeks. So with that in mind, could you tell us what financial distress that prospect would present to you if you were chosen?
Right. It would probably put me into a situation where I might miss a couple of house payments or a house payment.
Okay. All right. Knowing that, if you were selected to serve on the jury, would that affect your ability to focus on the evidence and give your undivided attention to the case?
I think it would cause stress in that scenario. Yes, sir.
Okay. And I understand your answer, and I'm not trying to badge you with these questions. But would that stress affect your ability to serve as a juror and focus on the case?
No, I think I can focus on the facts.
Okay. Thank you, sir. Nothing further.
Good morning, sir.
Good morning.
You mentioned that you thought you could get by with savings, but you might miss a house payment or two.
Yes, sir.
Would you be in any kind of danger of losing your house, anything of that nature?
Not likely, no.
Okay, so you have to tighten your belt up a little bit and think you can make it, though. Would that be something that you would be so stressed about, or be a pervasive feeling that you carry with you into the trial if you were selected to be on this jury?
And not so much the house, sir, but more just my professional situation with missing potentially 3 weeks of work.
I understand that. I understand.
Right.
If that kind of situation arose,
Yes, sir.
that's something that would be a shadow in your mind the whole time you're here.
Yes, sir.
Would that in some way diminish your ability to listen to the evidence and make decisions based on the important things that are coming to your attention here in the courtroom?
I think that missing work for that period of time might certainly cloud my ability to listen to everything, yes, sir.
Do you think that that type of stress would make it difficult for you to be fair and impartial? In other words, do your job as a juror if you were selected?
Right. No, I think I could probably make a decision based on the facts.
You just think it'd be in your mind?
I just think it would be, yeah, I think it would be a stress, but I could work under pressure.
Okay, so you can put it aside, you think?
I think so, yes, sir.
Okay, thank you, sir.
Thank you, sir.
Thank you, sir. You may step out.
Okay, thank you.
Respected jurors, exit the court.
No motion, Your Honor.
Judge, I have concerns about his ability to sit as a juror in this case because of the stress involving his financial situation, his work situation. I think he vacillated at some points in the conversation with Mr. Kroner and myself. He said he could do it. At other points he said it would get in the way. Just as an abundance of caution, I would move to strike him for cause for that reason.
The state does not agree.
I think the attorney used was cloud my judgment, and I'm going to go ahead and he provided that was possible. I'm going to go ahead and grant the defense motion in that regard. Number 110 is struck for cause. Number 112 indicates some knowledge of the case. ask you some questions. I ask you to respond in a strong voice, okay?
Okay.
Stay.
Thank you. Good morning, ma'am.
Morning.
Yesterday you indicated that you had learned something or gained some knowledge about this case in the past before you came to court. Is that right?
Correct.
What was the source?
The TV,
And was that recently or sometime closer to the event in 2011?
2011.
Okay. Was the source print or broadcast or internet?
TV.
You said it.
Did I?
I think, I don't know.
Did I?
Great. All right, ma'am. The defendant is afforded a constitutional right to be presumed innocent. And that right stays with her until and unless the state of Florida overcomes that presumption of innocence with proof in court by evidence beyond and to the exclusion of every reasonable doubt. Does that make sense to you?
Yes.
Okay. Did you hear Judge Battle's summary of the case yesterday at the beginning of when your panel was brought in?
Yes.
What I'd like you to tell us is everything that you can recall from the news that you learned about this case that was in any way different from or in addition to what Judge Battles stated in that summary.
No.
Nothing further?
No.
Okay. Did you see any photographic or video images of the defendant on the TV news?
Yes.
Well, was it, what do you call about that?
It was the part where she was coming out of the jail and shaking.
Okay. As a result of seeing that image, did you draw any impression or conclusion as to the defendant's guilt or innocence or her state of mind?
Her state of mind, maybe.
And what was that opinion or impression?
She seemed very distraught.
Okay. As a result of what you've seen on the news and any other information you have about the case, have you drawn any impression or opinion about the defendant's guilt or innocence?
No.
Okay. Is there anything about what you've seen on the news that you think might affect your ability to serve fairly and impartially in this case as a juror?
No.
Okay. Can you afford and give to Ms. Schenecker her presumption of innocence even though you've seen press reports about this case?
Yes.
Okay. Thank you, ma'am.
Mr. Trey?
Judge, I have no questions for the juror.
Thank you, ma'am. You may step out. She's actually more.
We do more than help.
You can have a seat, ma'am. Going to allow the attorneys to ask you a few questions. Ask them to respond in a strong voice, okay?
Okay.
Stay.
Good morning, ma'am.
Good morning.
Yesterday you indicated you had learned something about this case from some other source outside the court. Is that correct?
Correct.
Okay. Was that recently or about the time of the incident when you saw this?
About the time of the incident.
Okay. Have you seen anything recently?
I have not.
Okay. The defendant, like any other person accused of a crime, is entitled constitutionally to be presumed innocent. That presumption stays with her until and unless the state of Florida, through evidence presented in court, proves her guilt beyond a reasonable doubt. Does that make sense to you?
It does, correct.
Do you recall hearing the summary that Judge Battles provided to the entire panel yesterday about the case?
Yes, correct.
What I'd like you to do is tell us everything that you learned from the media about this case or about the defendant that was in any way different from what Judge Battles told you, or was in addition to what Judge Battles told you, okay? Please tell us.
Sure. It's basically what he outlined, the main story of it. I was, from the news, it seems like they were portraying her as guilty from what I heard.
Did you see one broadcast or multiple broadcasts?
Multiple.
And was your information confined to the source from broadcast television, or was there print media and internet too? Or?
No, just news.
Did you see any images of the defendant, photographic or video, during those broadcasts?
If I remember, it was just, photographic, from the news.
Well, what I mean by photographic as opposed to video is a still photo as opposed to moving video?
I think it was moving video.
Okay, and what do you recall about that video shot or view?
I remember, I think, her being taken away in handcuffs.
Okay.
Again, it was a long time ago.
Sure. Did you have any impression, conclusions, or opinions about the defendant's guilt or innocence or state of mind as a result of seeing that video?
No, not as of from the video.
Okay. Have you drawn any opinion or conclusion about the defendant's guilt or innocence as a result of what you've seen on the news?
I have not. It was tragic and very sad, but I have not.
Okay. Is there anything about the information you saw on the news that would prevent you from presuming this defendant innocent as she's entitled to be?
From what I saw?
Yes.
No.
Okay. Do you have any opinion or impression that would prevent you from presuming her to be innocent?
I mean, I would need to hear everything.
Okay. And I understand what you're telling us. You don't want to prejudge anything, is that correct?
Correct.
Okay. What the presumption of innocence really boils down to is that for the jury as a whole and each individual juror, the starting point has to be that she's innocent.
Right.
And that it's always the exclusive burden of the state of Florida to prove her guilt beyond a reasonable doubt by evidence in court. Fair enough?
Correct.
Okay. Can you give her that starting point of innocence that the Constitution requires?
Yes.
Okay. It's important that the jury base its verdict solely on what's in court, the evidence presented in court, and not what's reported in the media. Can you do that?
Yes.
Is there anything about what you've learned or heard about this case or the defendant that would prevent you from being a fair and impartial juror?
My only hesitation is that I'm a very sensitive person, and the whole case is very kind of upsetting to me.
Yes, ma'am.
So that's my hesitation.
Okay. The law does not require, and no one here expects people to check their emotions at the door. Various people will have various reactions to what's seen and heard in the court during the course of any trial. That's normal, that's human behavior. You know yourself better than any of us here, obviously, given we've only had a few minutes with you. Do you think that your sensitivity would affect your ability to give the state of Florida or the defendant a fair trial?
It could.
Okay. And could you articulate on how you think it might do that?
I feel like I'm someone who likes to see the big picture, and I need to have all the facts, and which is why I'm so undecided about it currently, even with knowing a little bit about it. But given the situation and the case itself, I work with children. It's just it's close to home. It's just
Okay.
hard for me.
Thank you, ma'am.
Do you think that your work with children and your sensitivity to them is the main issue that you're concerned about in terms of being a juror in this case?
Yes, and from knowing what she is being convicted of.
Okay. Now, you mentioned that you saw things back in 2011. Have you continued to see bits and pieces about this case as it went along?
I have not.
So when you speak this morning to us about what you do remember as far as things you've seen, that's from back at the time of the incident in 2011?
Correct.
Well, what is the main source of news that you normally get involved with to learn?
I watch the local news.
Just local? Does it matter which station to you, or just whatever's on?
Whatever's on, or I do watch a lot of Fox News, so I'll watch that.
Did you find yourself emotionally moved at the time that you were watching this in terms of the sensitivity you've just explained to us this morning?
Yes.
You probably never in your wildest dreams thought you might be in the situation of being this jury at some point in time.
Correct.
Now you're here. Is that something that you feel strongly that would interfere with your ability to be fair and impartial, not only to Ms. Schenecker, also to the state of Florida?
I do. That's why I wear my...
So if I understand you correctly, this is not so much based on you having a preconceived opinion about guilt or innocence from things you saw in the media. It's your sensitivities, the work you do, and the things that you're sensitive to that you feel would stand in the way.
Correct.
Thank you very much. Nothing further, June.
You may step out.
Okay, thank you.
She's exiting the courtroom.
Which I move to strike through number 114 for cause.
No objection. Without objection, 116 is struck for cause.
114, Judge.
I'm sorry, 114. And next, we'll bring in 116 to engage some hardship and knowledge. Yes, ma'am, you can have a seat. We're going to allow the lawyers to ask you a few questions. I'd ask you to respond in a very strong voice, okay?
Okay.
State.
Good morning, ma'am.
Good morning, sir.
Yesterday, you indicated that service on the jury may present a hardship to you. Could you explain to us, please?
Okay, first of all, I have a 16-year-old son that I picked up every day after school because he stays late for football practice and he finishes like 5:30, 6:30. And I'm the only one that can pick him up. And then I have my daughter who is expecting anytime she's about to have a baby. And she wanted me to be there for her when the day comes. And then, and for the, like the stories in the newspapers, I've been hearing, all the details and a lot of things in the newspapers and watching TV from the previews.
Okay, let me talk about the first subject first, the hardship. Typically, the court works until 5. Mayor, what part of town is it that you would have to pick up your son from in relation to downtown?
Okay, he goes to school in Dover.
Okay, so it's further south.
Yes.
Okay. All right. It would be probable that you would likely be able to pick him up more often than not, but I couldn't. There would be no guarantees as to when we would get out any special time every night. It's a practice to be out at 5 o'clock, but it could be later.
It could be later.
Yeah, it could be. In those occasions when we might work a little bit beyond 5 or so, would your son be able to catch a ride on any given night with anybody else?
I'm not sure because I'm the one that usually pick him up.
You've indicated that your daughter was pregnant
Yes.
and she's due any minute?
Any minute. She's.
Okay. Well, congratulations.
Thank you.
Are you her support during her pregnancy?
Yes, I've been there for her.
Okay. Does she live with you?
No, she's on. She lives on her own, but you know, for those last couple of days, she's been coming to the house just to be. Yes.
Okay. If you were selected as a juror, knowing about your son's situation and your daughter's situation, especially the birth, is this your first grandchild?
Second.
Okay. Would that affect your ability to serve as a juror and give this case your sole and undivided attention?
It would be hard for me.
What are your daughter's plans as far as the immediate days or initial weeks after she gives birth, as far as the care of the children?
Okay. It's her first. It's my other son. Okay. I had plans to be there with her, especially the first couple of days, because it's her first baby.
Okay.
So.
All right. You've also indicated that you've been exposed to some information about this case. Is that right?
Yes, sir.
Was that from the media?
From the media.
And was that recently or closer to 2011 when this occurred?
When it first happened, and then recently it's been in the news, in the media.
And what do you recall hearing from the news?
That they selecting jurors, and you know the case, what happened in 2011, I believe.
What details do you remember being reported in 2011?
The lady, Schenecker, I believe, had killed 2 of her children.
Okay. Did you see any photographic or video images of the defendant during what you saw on TV?
Yes, I saw on TV. That's about it.
What do you recall seeing of the defendants?
The first time that I saw the news, when they had, when she was booked and the way, she presented herself.
And did you draw any impressions about the defendant's guilt or innocence, or about her state of mind when you saw the video about how she presented herself?
Did I draw conclusions?
Yeah. What was you thinking when you saw that?
I thought she was guilty.
Do you have an opinion as to whether she's guilty or innocent as you sit there?
Yes, sir.
What is that, ma'am?
Guilty.
Okay. The law presumes everybody charged with a crime is innocent. And that's the starting point for the jury. And that stays with the defendant unless and until the state of Florida, the prosecution, proves by evidence in court that the defendant is guilty beyond and to the exclusion of every reasonable doubt. As a result of what you saw on the media and the opinion or impression that you formed, do you believe you're capable of giving Ms. Schenecker her constitutional right to be presumed innocent?
I'm sorry, but I don't think so.
Okay. Thank you for your candor.
Thank you.
Any questions, Counsel?
No questions, sir.
Thank you, ma'am. You may step out.
Thank you.
She's exited the courtroom.
Judge, defense would move to strike juror number 16 clause.
No objection. 116, struck because the motion in defense without objection. 117 indicates hardship. have a seat, sir. We'll allow the attorneys to ask you a few questions. We ask that you speak up in a strong voice so we can hear you up here, okay?
Good morning, sir.
Good morning.
You indicated yesterday that service on the jury for 3 weeks would cause you a hardship. Would you explain the nature of the hardship, sir?
I work at a hotel in a kitchen, and it was indicated to me that my schedule would be changed, and instead of working mornings, I will be working evenings, and that will probably give me less hours since I'm paid on an hourly basis, and that's unacceptable for my family.
So would it be your intent, if you were selected as a juror, to, well, let me start over. Was that change as a result of the prospect of you having to serve as a juror?
I believe it's on a needs basis. I was told by my sous chef that we might have to change me to evenings, even though my schedule has been flexible in the past.
And I'm sorry, I guess my question was that change as a result of the fact that you had jury service?
Yes.
Okay, all right. And that may cause a reduction in your hours and correspondingly a reduction in your salary, is that correct?
Yeah, because there's only so much time in the day.
Correct. Would it still be your intent, were you to be selected as a juror, to go from jury service to work?
If I need to provide for my family, I have to provide for my family.
And excuse me for asking these private questions, but we have to, so that we can make a legal determination of whether the hardship rises to what's known as legal cause, okay? And there's no other way to determine that without getting in your business, so to speak, okay? Are you the, you provide for yourself and your, whom else?
And my wife and my daughter.
Okay. Do you have any other source of income other than your income?
Yes, they both. My wife works.
Okay. Any reduction of pay, of course, it causes financial distress. We recognize that. Can you tell us how you think that the corresponding reduction in salary and hours would affect your ability to live the life you lead?
Well, paying the mortgage is one thing. Paying the electric bill is another. Also, it's going to be a lack of sleep. Going from here to work, possibly getting home at midnight or 1 o'clock in the morning, doing that for a 3-week basis is not good.
Do you have any concern that that schedule or the financial distress and hardship that jury service would impose would affect your ability to give the trial and the evidence your fair and undivided attention?
Lack of sleep deprivation would probably cause a lack of focus, yes.
And do you think that would affect your ability to serve as a fair and impartial juror in this case?
I do.
Okay. Thanks for your candor, sir.
Thank you.
Any questions?
Question, Judge.
You can step out.
Thank you.
He's left the courtroom.
Judge, I move you straight 117. No objection.
Ready? 118 indicates some knowledge of the case.
This way, please, sir. There's a seat for that white microphone
You can have a seat, sir. We're going to allow the attorneys to ask you a few questions. I ask that you respond in a strong voice so we can hear you out there, okay?
Okay. Good morning, sir.
Good morning.
Yesterday, you indicated that you had some knowledge about this case from some source outside the courtroom before you got here. Is that right?
Correct.
What was the source?
I remember the story from television or newspapers some years ago.
Closer to the time of the event?
Correct.
Do you recall seeing or reading anything recently about this case?
No, other than the image of, I guess, the pending trial on television, but the sound was not on. I just noticed that that was an event coming up.
And the image that you referred to, was that a courtroom image or was that something else?
That was the defendant.
And in what context was the defendant shown in that image?
I believe it was being transferred from one place to another by officers.
All right. Do you recall Judge Battles providing a summary of what the case is about when your section of the panel was brought in yesterday?
Yes, I did.
What was the source of your information? Was it broadcast television news?
I believe it was broadcast, yes.
Okay. Have you done any internet search for news sites that had content about this case?
No, I have not.
Or read anything in the newspapers?
No.
Okay. Can you tell me everything that you recall from those reports that was in any way different from or in addition to the summary Judge Battles provided? What other details have you learned about the case other than that?
I don't remember any details other than what the judge provided yesterday. My memory is a very basic understanding which was provided yesterday.
All right. The image of the defendant that you've referred to as having seen recently, did you see similar images in the past at or near the time of the event?
I believe so, yes.
Did you draw any impression or conclusion as to the defendant's guilt or innocence or her state of mind as a result of seeing those images on the news?
I would say no.
The defendant, like anyone else charged with a crime in our state or in our country, has a constitutional right to be presumed innocent of those charges. So, simply stated, the starting point for the jury has to be that the mindset she is innocent, and that presumption stays with her unless and until the state of Florida proves by evidence in court that she is guilty beyond and to the exclusion of every reasonable doubt. Does that make sense to you, sir?
Yes, it does.
Have you formed any impressions or conclusions about the defendant's guilt or innocence as a result of what you've seen on the media or any other information you learned about this case?
I have not.
Are you able individually to give Ms. Schenecker her presumption of innocence that the Constitution requires?
Yes.
Would you be able to hold the state of Florida to its burden of proving her guilt beyond a reasonable doubt?
Yes.
Do you have any concern that you would be able to return a verdict based solely on the evidence you see in court and setting aside or compartmentalizing what you saw outside? Could you do that?
Yes, I could.
Okay. Is there any reason in your mind that as a result of you were exposed to through the media, you think you may not be able to be a fair and impartial juror? Do you have any concern on that?
No.
Thank you, sir.
Questions, Mr. Frank?
Yes, Judge. Good morning, sir.
Good morning.
You mentioned that you got information back at the time of the incident back in 2011 from broadcast news. Do you have a particular news station that you favor more than others to get your news?
We tend to watch Channel 8 or Channel 13 at home.
Okay, and so what you remember seeing initially, including photos or videos or whatever, probably came from one of those sources?
Probably so.
Do you remember formulating any kind of opinion at the time that you were looking at that, even back then, about how all things should go in the courtroom, guilt or innocence, anything like that?
I don't recall. I try not to do that.
Okay, you make a conscious attempt to avoid that?
Yes.
Okay, and I take it that that's carried with you even to your appearance here in the courthouse this week?
Correct.
Okay. You mentioned that you didn't recall any particular details that weren't covered by Judge Battles in his overview of the facts of this case. Now that it's become somewhat of a point of focus, you've been asked probably by both of us now, in thinking about it, do you remember anything else whatsoever other than the overview that you were given?
No, sir, I don't.
Okay. And as we speak today, you have a fairly fundamental understanding of presumption of innocence. It's the old saying of innocent until proven guilty.
Yes.
We have, I take it you've heard that before.
I have.
And you believe in that?
I do.
Okay. And are you able, without any philosophical problems internally, are you able to attach innocence to our client as we speak?
Yes.
Okay, so you don't have any preconceived opinion one way or the other about anything related to this case as you're sitting here this morning?
No, sir.
Okay. Thank you, sir.
Thank you, sir. You may step out. Okay, number 119 indicates some knowledge of the case.
This one?
Yes, ma'am, right there. You can have a seat. Going to allow the attorneys to ask you a few questions. Ask that you speak up and respond in a strong voice.
All right.
Okay.
Good morning, ma'am.
Good morning.
Yesterday, you told us by standing up or raising your hand that you had some knowledge or information about this case that you learned from some outside source before you came here. Is that right?
Yes, sir.
What was the source?
The news.
What, print or broadcast or internet?
All above.
Was that something you learned recently or closer to the time of events in 2011?
Closer to the time of the event.
Do you recall seeing anything recently in the press, whether it be TV or newspaper or internet?
No, sir.
Okay. The defendant, like anyone else accused of a crime, is constitutionally entitled to be presumed innocent. I mean, and that's the starting point. A jury, to be qualified, must presume and say she's innocent unless and until the prosecution proves her guilt by evidence in court beyond and to the exclusion of a reasonable doubt. Do you understand that, ma'am?
Yes, sir.
You recall Judge Battles giving you a summary of what this case is about yesterday when your portion of the panel was brought in?
Yes, sir.
What I'd like you to do for us, if you could, is tell us everything that you recall from the news back when this happened that was gave you facts that were anyway different from or in addition to the summary Judge Battles gave you.
There wasn't anything different than what he said that I saw in the news.
Did you see any still photographic images or any video images of the defendant back then?
Yes.
What do you recall about that?
Her getting out of the cop car.
Okay. And did you draw any impression or conclusion about her guilt or innocence or her state of mind as far as a result of that image?
No.
Okay. What do you recall about that image?
Honestly, she was just shook up, I guess.
Okay. As a result of the information that you saw broadcast back around the time of the event, did you draw any conclusions or opinions as to whether Ms. Schenecker was guilty or innocent of the charges?
Yes, I did.
Okay. And what was that opinion or impression?
Guilty.
Okay. And how strongly did you hold that opinion to that?
I still hold it just because if there's kids involved. I just feel like I wouldn't be able to have an open mind about that.
Okay. And that answer was very clear, but please let me follow up with a few extra questions, okay? Is that opinion you still hold today?
Yes.
Is that opinion going to affect your ability to give her the starting point of innocence, that presumption of innocence?
It would.
Do you think that opinion will prevent you from being a fair and impartial juror?
Yes.
Okay, thank you.
Thank you.
Hold on,
Oh.
Mr.
Okay.
Schenecker.
Questions, sir?
No question, Judge.
Thank you, ma'am. You can step down.
Okay, thank you.
Mr. Strike, juror number 119 for cause.
No objection. 119, on motion of the defense without objection, the state is struck for cause. 120 indicates some knowledge of the case.
Wait, please. Is there a seat right there in the center in front of that back one? Yes, sir.
Right there is good, sir. We're going to allow the attorneys to ask you some questions. I'm going to ask you to respond in a strong voice, okay?
Okay.
Good morning, sir.
Good morning.
Yesterday you indicated that you had some information or knowledge about this case from some other source before you got to this courthouse. Is that correct?
Yes. It has been all over the news, and when it first happened, about 2 years ago, I was like, this lady killed her kids while they were sleeping, all because they were being mouthy.
Okay. Did you see anything recently in the news about this?
Yes, the day before yesterday, when was my first day, it came on the news that the first 100 people that were selected were, not let go because they had knowledge of the case. So they were.
All right. The defendant has a constitutional right, like any other person charged with crime, a right to be presumed innocent. That means that the starting point for the jury must be that she is innocent, and that presumption of innocence stays with her until the state of Florida, the prosecution, proves her guilt beyond and to the exclusion of every reasonable doubt. Do you understand that, sir?
Yes, I do.
So it's important, and the law requires that the jury base its verdict on the evidence presented in court. Does that seem fair to you, sir?
It is fair, but for me, it's very difficult for me to be impartial.
Okay.
Knowing that, one of these kids were killed while they were sleeping.
Okay. Sometimes the news doesn't get it right, despite their best and well-intended efforts. And that's why we're trying to ask folks whether they can set aside what they saw before they got into court and base this verdict on just what's presented in court. Do you think you're capable of doing that?
I don't think so.
Okay. Do you have an opinion or impression as to the defendant's guilt or innocence?
Well, I think the defendant, it's a clear case of, there's no other suspects or anything. I mean, it's like the kids didn't get to defend themselves. I mean, it's like she took the lives of two people, and now she's asking the court to spare hers.
Do you think that opinion would affect your ability to be a fair and impartial juror?
Yes.
Thank you, sir.
Questions?
No question, Judge.
Thank you, sir. You may step up.
Okay, thank you.
Prospective jurors asking the court.
Passenger to strike juror number 120 for cause.
No objection. Without objection, 120 is struck for cause. 122 indicates some knowledge of the case.
Please have a seat for the mic here.
Okay, sir, you can have a seat. We're going to allow the attorneys to ask you a few questions and ask you to respond in a strong voice.
Okay.
Stay.
Good morning, sir.
Morning.
You indicated yesterday that you had some exposure to information about this case outside the court before you came in. Is that correct?
Yes.
Okay. I see from your form that you were a retired attorney. Is that correct? So I'm going to assume that you're familiar with some of the concepts I'm discussing and not go into great explanation of them.
I am.
Was the information that you learned from the media,
Yes.
was that recently or closer to the time of the event in 2011?
Both.
All right.
Early then and then last Sunday's Tribune.
Okay, sir. You recall the judge's summary of the statement about this case
Yes.
yesterday? Okay. Can you tell us any information that you've learned about the case from the paper or from the broadcast news that was in addition to or different from what Judge Battles read to you?
In addition to.
Tell us what you recall, please.
Well, there was a discussion of purchasing the weapon several days before and some other things about a diary or some other written, as I recall.
Do you recall seeing any photographic or video images of the defendant in any of those accounts? You're aware from, I believe, you retired from your practice, is that correct? You're aware that the law and Constitution presumes the defendant is innocent until proven guilty?
Of course.
And of course the state's burden of proving that guilt beyond a reasonable doubt, sir?
Yes.
Have you formed any fixed or definite opinion about the defendant's guilt that would affect your ability to presume her innocent and hold the state of Florida to its burden of proof?
Yeah, I believe I have.
And tell us about that, sir.
Well, you know, I have 2 children, 2 stepchildren, and 7 grandchildren, and it's such a horrific crime to kill your own children. It's very disturbing to me. It would be very difficult, I think, for me to accept insanity plea.
Okay. Do you believe, do you hold that opinion presently?
Yes.
And do you believe that would affect your ability to serve fairly and impartially in this case?
Yes, I do.
Thank you, sir.
Questions, Mr. Brennan?
No, Judge.
Thank you, sir. You may step out.
Thank you. Judge, I would be straight to 122 regard.
No objection. 122 is special cause of motion of defense without objection from the state. 125 indicates hardship. Okay, you can have a seat, sir. We're going to allow the attorneys to ask you a few questions. I ask that you speak up in a real strong voice so we can hear you.
Okay.
Stay.
Thank you. Good morning, sir.
Good morning.
Yesterday you indicated that service on the jury for the next few weeks would cause a hardship. Would you explain what the hardship would be, sir?
I do believe it would be hardship simply because 3 weeks of my family's income would definitely put a burden on us. We'd definitely not be able to pay a house payment.
All right, sir. What do you do for work, sir?
I'm in the medical field. I do MRI.
And does that business provide any compensation for jury service?
It does for my paid vacation. So they're taking out my paid vacation for me to be here today.
You'd have to burn your leave?
Yes, sir, and I only have 1 week.
Okay. Are you the sole source of income for your family, sir?
The sole source? No.
We understand and accept that being without income presents financial distress to anyone in that situation. So we're not minimizing what jury service may affect you. But I do have to ask some additional questions, sir.
Go right ahead.
Do you have any other source of income in addition to your wife's working, whether it be savings or investments or family, that could assist you financially for the time that you're not compensated by work?
I do.
Okay.
Could you describe specifically how missing that the payment for whatever period of time would affect your family and living situation for us?
Well, just as an example, evidently news got out for this situation already, and evidently my wife had seen something. Unbeknownst to me, I never said a word to her. I get home yesterday, and I got fired and drilled about how if I had to miss work for 3 weeks, that it'd be a huge detriment to my household. And I had to hear that for a good 30 minutes before she stormed off to bed.
Okay, so in addition to the financial distress, there may be some relationship distress or stress, is that correct?
I would have to say yes. I certainly wouldn't have thought that yesterday.
And I understand that, sir. Would your service on the jury affect your ability to focus, would the hardship presented by jury service affect your ability to focus and give your attention to the case and the evidence were you to be selected as a juror?
I would honestly have to say yes.
Okay. Thank you, sir.
Questions, Mr. President?
No questions, Judge.
Please step out.
Move to strike Judgment 125 for cause.
No objection.
125 is struck for cause without objection. 126 indicates some knowledge of the case.
I'm sorry.
Right there, you can have a seat. We're going to allow the attorneys to ask you some questions. Okay, ask you to speak up, Mr. Holmes, this is your response.
No problem.
Mr. Pruitt.
Thank you. Obviously, you can follow the instructions.
I can project my voice.
Good, thank you. Ma'am, yesterday you told us that you had some information or knowledge about this case?
Yes, sir.
Okay. And that was something you learned before you came into court?
Yes, sir.
Okay. What was the source of the information?
This, when the case came, when this happened, 2008? Yeah. It was news, the newspaper.
Okay.
I read it and watched it.
Did you see or learn anything from the media recently about this case?
No, sir.
The Constitution of the state of Florida, the United States, says that anybody charged with a crime is presumed to be innocent of that charge, and that presumption stays with the defendant until the prosecution, through evidence introduced at trial, proves the defendant's guilt beyond a reasonable doubt. Does that make sense to you, ma'am?
Yes.
Okay. And it's important that the case be decided by the jury based solely on the evidence introduced in court, and to that alone as the basis for the verdict. Does that make sense?
Yes.
Okay. Judge Battles yesterday read a summary to you of what the case was about. Did you recall what he told you yesterday in general?
Yes, sir.
Okay. Did you see multiple accounts or just a single account back near when the event occurred?
Originally when?
Yes, ma'am.
Multiple.
Okay. Did you draw any opinions or conclusions as to whether the defendant was guilty or innocent as a result of what you saw in the news or read back then?
Yes, sir.
Okay. And what was your opinion or conclusion that you drew?
Am I allowed to say?
Absolutely, that's why we're doing this.
My opinion, based on the information that I was exposed to, I think she's guilty.
And is that an opinion you still hold today?
Yes, sir.
Is that an opinion, well, let me ask you, is that an opinion that is going to prevent you from presuming the defendant innocent?
Yes, sir.
Is that an opinion that will prevent you from being a fair and impartial juror in this case?
Yes, sir.
Thank you, ma'am. I appreciate your candor.
Questions, counsel?
No, Judge.
Thank you, ma'am. You may step out.
Thank you.
Defense moves to strike 126 for cause.
No objection. 126 is struck for cause. Motion to defense without objection from the state. 127 indicates hardship and have a seat. We're going to allow the attorneys to ask you a few questions. I'd ask you to respond in a strong voice, okay?
Okay.
State.
Good morning, ma'am.
Good morning.
Yesterday you indicated that jury service for the better part of 3 weeks would cause you hardship. Would you explain it to us, please?
I recently found out that I'm expecting, and
congratulations.
Thank you. However, obviously, I'm going to be taking time off for that as well, financially. And in addition to, as a result, we are pushing up our wedding date 5 months. Okay. So rather than getting married in November, we're getting married in August. So just financially and the time away from work, it may cause some hardship.
Okay. Are you compensated for jury service by your employer?
I'm compensated for 3 days.
Okay. With all that going on in your life, if you were selected nonetheless to serve on this jury, would that affect your ability to serve as a fair and impartial juror?
Yes, I would hope so. Yes.
You would hope that it would. I may have asked that backwards. Let me say that differently, okay? If you were selected as a juror, knowing everything that's going on in your life, would you be able to focus and give the evidence and the proceedings your undivided attention?
At this time, probably not. Only because if I'm moving it up, and I just literally found out on Sunday. So I wanted to do my civic duty, and I chose not to postpone it because of this. But with the severity of this case and what it entails, I can't 100% say that I would want to be, and I would try to be. I just know that there's a lot of other things going on as well. So depending on when this case went to trial would probably affect it.
Okay. In a nutshell, are you uncertain as to whether you could perform your role as a juror? Is that it? I mean, with everything going on?
Unfortunately, yes.
I appreciate your candor. Thank you.
Thank you.
Mr. Brett?
No questions, Judge.
Thank you, ma'am. You may step out.
Move to strike 127 for cause.
No objection.
Granted, 127 is struck for cause. 128 indicates hardship. Yes, ma'am, you can have a seat right there. They're going to ask you a few questions. I'm going to ask you to respond in a strong voice, okay?
Okay.
Stay.
Thank you. Good morning, ma'am.
Good morning.
Yesterday you indicated that service on the jury for the next 2.5 weeks or so would cause hardship to you. Could you explain, please?
Yes, because I work and I live on my own, so I have to pay bills.
Okay. Are you the sole support of yourself?
Yes.
All right. Do you have any dependents that you support also?
No.
Okay. Excuse me, but I need to ask some prying questions so that we can make a fair determination, okay? Do you get paid for any jury service by your employer?
I don't really know. Not sure.
Okay. Is that something that you would be able to find out perhaps by a phone call?
Yeah.
Okay. All right. If you were compensated by your employer for your time in jury service, would that remove the hardship?
Correct.
Okay.
Yes.
All right. Your Honor, may we approach?
Yeah. Go ahead and make that phone call check on that. We'll call you back a little later.
Okay. Thank you.
Number 130 indicates some knowledge of the case. Yes, sir, you can have a seat. We're going to allow the attorneys to ask you some questions.
Okay.
Just ask that you respond in a strong voice so we can hear you.
Okay.
State.
Thank you. Good morning, sir.
Good morning.
Yesterday, you indicated that you'd had some exposure to information about this case before you came to court. Is that right?
That's correct.
What was the source?
Media reports.
Broadcast, internet, or print?
Both, but in fairness to the court, I have been a media member for a number of years. So I'm an avid reader.
That's good. Okay. This defendant, like anybody else charged with the crime, has a constitutional right to be presumed innocent.
That's correct.
That presumption stays with her until the state, the prosecution, proves her guilt by evidence in court beyond and to the exclusion of every reasonable doubt.
Correct.
Did you hear the summary that the judge provided to the jury yesterday about the case?
I did.
Was there information that you learned from the media and that you recall now that was in any way different from or in addition to what the judge gave in summary terms yesterday?
Yes.
What do you recall?
I recall that the defendant purchased a gun, and because of the law in Florida, it's a 3-day waiting period. I believe it was 5 days after the purchase of the gun that the children were shot. The one child was shot in the van after soccer practice. The daughter was shot in her bedroom, in the back of the head and also in the front. I read the emails that were printed. The one that sticks in my mind is the prolonging of the massacre. The video of the defendant coming out. Also that she was found in the pool area, believed to have been intoxicated and maybe some drugs.
As a result of your exposure to that information from the media, have you formed any fixed or definite opinions as to the guilt or innocence of the defendant?
Well, since the defense is using not guilty by insanity, I feel that we're not here. Whether she did or did not do the act, it's a question of what institution she will be going to, whether it'll be a prison or a mental health care system.
If you were selected as a juror with the information you've seen in the press and with what you've just told us, would you be able to afford or give to the defendant her presumption of innocence?
It's my duty to try my best. But because the state has taken the death penalty off the table, I believe that that she should not be back into society.
Okay.
And so I would try my best, but it would be very difficult.
Do you have some doubt as to whether you could be fair and impartial in this case?
I do have some doubt, yes.
All right. Thank you for your candor, sir.
Thank you.
Questions, Mr. Trennan?
No, Judge.
Thank you, sir. You may step out. He's actually in the courtroom.
Judge, I move to strike juror number 130 for cause.
No objection. 130 is struck for cause and motion of the defense without objection to the state. 131 indicates some knowledge of the case. A little bit further, man. There you go. We're going to allow the attorneys to ask you some questions. I ask you to respond in a real strong voice so we can hear you out here. Mr. Burke.
Good morning, ma'am. Yesterday you indicated that you had some knowledge or information about this case from some outside source. Is that correct?
Yeah.
Okay. Was that something you learned recently or about the time of the offense in 2011?
No, recently, just a couple of conversations.
Okay. Did you see anything on the news, or was your information just from talking to folks?
Just talking.
Okay. Can you tell us about those conversations? With whom were those conversations held, and what did you learn?
Other jurors here yesterday, just a couple things he said. He said that
he thought it was premeditated, or comments about what he read.
And what did this fellow say to you about what he read about the case?
That she wasn't going to be, she had two options, either life or something to that effect. It's life, or if she's sick, staying somewhere else.
Okay. Did this person talk to you about the facts, supposed facts, that that person had heard or learned?
No.
Okay. Did you ever see any media coverage about this case, either recently or in the past?
No.
The law requires, and what the juries has to do, is base a verdict solely on evidence that's presented in the court, and can't base the verdict on information or opinions from people outside the courtroom. Do you understand that?
Yes.
Does that seem to make sense to you?
Yes.
Okay. The defendant has a very important constitutional right. That's the right to be presumed innocent. Simply what that means is the starting point for the jury is that she's innocent. And that starting point, that presumption of innocence, stays with the defendant until it's overcome by the prosecution, by proof presented in court, beyond and to the exclusion of every reasonable doubt. Do you understand that?
Yes.
Okay. As a result of what this fellow has told you the other day, did you draw any impression or conclusion or opinion as to the defendant's guilt or innocence?
No.
Okay. Is there anything about what that fellow said to you or about what you learned from him that's going to affect your ability to serve fairly and impartially?
No.
Can you presume this defendant innocent? Can you have that starting point that the law requires that she is innocent until proven guilty beyond a reasonable doubt?
Yes.
Okay. Is there anything about what that person told you that you think may affect your ability to serve on this jury?
Just that there's children involved.
Okay. The judge advised yesterday about the facts of this case. And was that something that you learned from the person or from the judge yesterday?
The person.
Okay. Do you recall that was also indicated in the statement of facts from the judge?
Yes.
Okay. All right. May we approach, Your Honor?
Yes.
Ma'am, you've indicated that the fact that the persons that were killed in this incident were children would affect you and your ability to serve in some fashion. Can you tell us what you meant?
I just feel very strongly about my children. I think that would be difficult.
Okay. And that's very understandable. The law does not require you to set aside your personal experience or your emotion. No one's essentially going to ask you to be an ice cube as a juror, so to speak. The question is, however, whether the fact that the persons that were killed in this incident were children, is that going to be a fact in and of itself that will prevent you from giving either the state or the defendant a fair trial?
No.
Is that fact going to prevent you from basing your verdict solely on the evidence, or can you still do that?
I can still do that.
Thank you.
Questions, sir?
Good morning.
Good morning.
How you feel strongly about your children, and you just, in response to a question, you said that's something that is an area of concern for you. How does that, in your mind, affect how you might be as a juror?
Emotional.
Emotional. Do you feel like the emotions that will be attached to that subject would stay with you throughout the length of the trial if you were selected to be on this jury?
Probably.
Do you feel like there's a possibility that those emotions could affect how you decide, or how you hear the evidence, or how you listen to the evidence, or how you even think about either Ms. Schenecker or the state or the state's witnesses? You feel like that might be a factor for you?
I'm not sure.
You don't know. You don't know until you get in that situation.
Yeah.
But it's an area that you must have concern about, or you wouldn't have raised that today, right? You're the only person that knows the answer to that. We're trying to find out, you heard what the judge said yesterday when he was talking about our need for jurors that can listen just to the evidence in the courtroom and try to make a decision based just on what they hear from the evidence, just from the witnesses who are in the courtroom. You heard that, right?
Yes.
And so that's what our need is. And the judge said we need some help on this one. We need people. So we're looking for people that are able to do that. And you're the only one that knows how you are going to react to that. Is your feeling about children so strong that it's going to interfere with your ability to be fair and impartial to both sides in this case?
No, I can still be fair. I believe I can be fair.
Do you feel like your strong feelings have created in you some opinion or impression of how this should go even before it gets started?
No.
Okay, so you're a clean slate. You don't have any opinion one or the other about guilt or innocence?
No.
Okay. And as it stands right now, Ms. Schenecker is completely innocent. Are you comfortable with that, given your feelings about the subject matter that will be perhaps involved in this case, according to that juror that you talked to?
Yes.
Okay. You don't have any problem attaching innocence to Ms. Schenecker and waiting to hear the evidence to see what happens?
Yes.
Okay. Do you have any concerns or reservations on this subject that maybe we haven't been artful enough in our questioning to be able to get you to be able to explain what your concerns are?
No.
Okay. And you mentioned that the main source of information you have about the facts of this case, or what you think the facts are, came from your discussion with the juror when you were waiting out there?
Correct.
Okay. You didn't have any knowledge on your own from having watched television or anything like that?
No.
Are you an internet person? Do you like to look at things up on the internet?
Not really.
Okay. Did you ever try to look this up on the internet?
No.
Okay. Are you a newspaper reader?
No.
Okay, so did you ever read any articles about this?
No.
And again, I guess for the last time, I don't mean to make you feel uncomfortable, but have you formulated any impression about this case, about guilt or innocence of Ms. Schenecker prior to this morning, prior to us talking this morning?
No.
Another question, George?
Ma'am, I will ask you one question. Now, you indicated that someone spoke with you or mentioned this to you yesterday, correct? That's your source of information?
Yes.
Approximately when was that?
Yesterday morning, afternoon.
In the afternoon? Mm-hmm. Okay. Do you recall who that was that made mention to you?
Yes.
Okay. Do you know that individual by name?
No.
Okay. All right. Just a second. Let me have counsel first. Yes, ma'am. I'm going to follow up just a bit. As far as the person that made mention to you about this, do you remember, for example, a juror number? I know that's someone.
105. 105.
Okay, thank you. All right, and when those comments were made, were there other people present?
Yeah, we were in the room. What was it? A couple of people.
Do you remember specifically? I know it's very hard. Anyone else that may have been present privy to that?
Sitting next to me, but I don't remember her number.
Just one person?
There was another one, but she already left.
Okay, so there was one other person, and that was it, right?
Correct.
Okay, so basically that person made comments, you're present, one other person present who has already departed, and then one other person who is still present, correct?
Yes.
Okay, all right, well listen, thank you so much, and we'll let you step out. And I'm looking at the clock. We're going to go ahead and take that morning break. It'll be about 20 minutes.
Judge, I have a motion for cause for 131.
Okay.
Let
me hear from the defense on that.
Judge, she expressed that the only knowledge she had about this case came directly from a conversation with another potential juror. She feels at this point that this involves children in some way. She expressed great sensitivity and strong feelings about anything involving children, although she didn't go any further with that. I'm concerned about her ability to be fair and impartial, particularly in light of her inability to follow instructions that have been given to her by the court earlier in so basic of an area as such as not communicating with someone else about the case. So I would strike the term of 131 for cause.
Well, my first response is there was no indication that juror violated the court's instruction as being a recipient of somebody else's statements in an open room. The record does not support that. Secondly, this juror candidly indicated that the fact that there were children involved would cause her to be emotional. However, she unequivocally, repeatedly stated that it would not cause her to be biased or unfair. She was still for the kind of presumption of innocence, and the whole state was burden of proof. Nothing in the law, I suggest, Your Honor, requires a juror to view the evidence totally void of emotion. And that's all she said, was that her emotional sensitivity to the fact those kids would affect how she viewed the evidence. But I suggest, Your Honor, that that's not disqualifying, because the law does not require us to get feeling automatized as jurors. Nothing further.
Anything else?
Nothing further.
Instructions are somewhat clear about not allowing anyone to say anything to you in your presence. There comes some point when that occurs. The expectation is that it stops instantly. Taking the totality of the statements of 131 without any attaching any wrongdoing to her, I am going to grant the defense motion. However, before she's dismissed, I'll speak with the bailiffs. Okay? And we're going to go ahead with that and take that 20-minute break for the court staff and everyone.